Welcome to the program. My name is Marty Shenkman, and I'm joined by a friend and colleague, very smart guy, Bob Keebler. And we're going to talk. Mostly, Bob's going to talk. I'm gonna just learn and listen about portability. Really critical for consideration for estate administration. And Bob has a lot of great insights, not only on portability itself, but how it fits into the broader planning scheme. And we're going to talk about all of that as well. Bob, you take it away. If I don't advance at the right pace, just give me a holler, and I'll try to add a few 2 cents here and there.
Well, thank you, Marty. So what is portability? Portability is I die and my wife receives my exemption. That's as simple as portability is. And portability basically came into law, give or take 2010. And so if husband dies, we'll have the gentleman die first. His exemption can be transferred to his wife. So if you have a pencil, just take 13,990 times 2. We'll call it 14 times 2, $28 million. That is what works for gift and estate tax purposes. But Marty, first thing we have to know is that doesn't work for GST. Okay, so it doesn't work for GST. Now, to obtain portability, you have to file a return, a federal estate tax return. The other thing we need to be careful, paranoid about, is that some states allow portability and some states do not. And I'm not going to try to create a list. That's your job as a practitioner in that state to figure out what your state does. If I file a timely 706, portability works. If I fail to file a 706, unless I can correct that, portability doesn't work. So basically, we can file a timely 706. We could do an extension and buy 6 months. So let's start right there. Marty, you represent Ethel. Ethel is 99 and a half, okay? And her husband, Elmer, just died. We believe she's under the exemption, under the 14 million, but not that she's close to 14. So we really don't need Elmer's exemption. But on the other hand, if we sunset, we need it. What would you do? Rather than going through the whole 706 process, you could extend a return, which could give you 15 months from Elmer's death to decide what to do. Now, here's the critical thing. If you fail to file, and let's just say the exemption is 14 million. I die and I'm at $12 million. My wife doesn't file. There's 2 procedures that allow you to correct that. But if I was at 16 rather than 14 and I died and no one filed a federal estate tax return, then you cannot correct that. And we're going to spend some time and we're going to talk about that. So if you're over the mark, if you're above the exemption at the first death, you do not receive any grace under the regulations or under the statute. You can't fix it. Very important. Now, a couple things that are old problems and a couple things that are new problems. The old problem is very much like in baseball, Marty. Every once in a while, the CPA and lawyer both watch the ball drop to the ground between them, okay? And that's a dangerous thing. So there has to be really good communication between the lawyer and the CPA and who's going to pick up the 706. Now, the third thing or second thing, which is even more troubling, is, and for the financial advisors listening, don't be this guy, please. Marty, we've had rulings that we had to get from the service where the financial advisors boxed out the lawyer and accountant because everything was joint property. It was passed by beneficiary designation form. They determined that there were no tax or legal issues that merited the involvement of the lawyer or the CPA. Well, sure enough, they missed the 706, okay? And that's a real problem. So it's just very important for everybody to be collaborative. Now,
Bob, let me interject a couple of quick comments. I don't know if this is exactly the right place, but since you brought up financial advisors, so a couple of comments. And if it's the wrong place, forgive me. First, I think it's really important that practitioners, the attorneys, the accountants, financial advisors, anybody that has any touch on a client from a financial perspective, understand how important portability is. And one of the things that I think is a real loss for clients is people on the lower wealth straw, and I'm not going to define it, don't file. Just like you said, they assume there's no tax problem. The problem with that simple approach is you may save the cost, and you'll explain a little more what's involved with the simplified portability 706 when we get there. But this stuff is really important for even clients worth, and forgive me, $3-4 million, and maybe even under. Why? The Democrats have proposed for more than a decade, well more than a decade, modifications that often have included reducing the estate tax exemption down to $1 million. If you don't get portability and secure that election, which is not that hard and that costly to do, if the surviving spouse dies at a time where the Democrats gain control in Washington, we all know it's a pendulum, it swings back and forth. And even if the Republicans succeed, which I don't think they will, in repealing the estate tax, you don't know what the next administration, whether it's in 28, 32, whatever, comes in. If it's Democrat, they may reinstate an estate tax, they may lower the exemption, they may do everything. It doesn't make sense to me for the modest cost involved not to grab this exemption and secure it while you can't. We can't predict the future. So I think everybody involved should address it. Let me add on to your comment about financial advisors. Financial advisors for smaller wealth, and I think smaller, and forgive using that term, when somebody's under the exemption, a $10 million estate, not an insignificant amount of money, they may be inclined to say, golly, the exemption's 14, I don't have to do it, but the exemption may go down. And if it's a couple with 20 million, maybe they're still not having it on their radar. The financial advisors should advise everybody with more than $1 million. I don't know what the right number is, but everybody with substantive wealth to talk to an accountant and get a portability return filed. How do you feel about that? I think a lot of people are losing it, and they may live to regret it.
If there's any chance that the surviving spouse's estate at any point in time will exceed the exemption, you should file for portability.
Yes. And we don't, how can we predict what that's going to be when somebody dies? The tax system is so unpredictable. I mean, I feel like the more years we practice, the more uncertainty we seem to face. So I'm sorry to interrupt, but it just seemed to, to segue into that.
No, I met with a lady who thought she was going to die literally in 1990, Marty, and she's still alive. And she's nearly 100.
Wow.
And I'm just saying, we don't know how long people are going to live. So we have to be careful. Now, so Marty, the other thing we can do, let's say that 3 years ago, somebody's husband died, they didn't file a 706. There's a revenue proc that allows them to go back up to 5 years from date of death. We'll look at that in detail. But that revenue proc only applies if the husband, the gentleman that died, was below the exemption at the point in time of his death. So if the exemption at that point in time was 12 million, he was at 13, he's sunk. Can't go back and fix it. If all else fails, say we get somebody that died in 2012, more than 5 years ago, obviously, they can go to the government and they can ask for 9100 relief. They can ask for the ability for 120 days. I just got one of these rulings back earlier this week. For 120 days after receiving the ruling, you can go back and file basically a new 706, a de novo 706. Now, to qualify for 9100, again, if you were over the exemption was 12, but you were at 13, you're sunk. The IRS does not have the authority to grant relief. They can only grant relief if you were under the exemption in the first place. So we have to take that to heart. Let's look at the next page. Very quickly, Marty, all of this is in section in tax imposed under sections 2001 through 2010 of the Internal Revenue Code. That's where portability comes from. We didn't always have portability for some of the practitioners that are that graduated after 2010. Before that, we didn't have portability, and you had to fund a bypass trust. Now, the bypass trust is still more viable, has a higher degree of efficacy when you have a state estate tax or when you want to use your GST. Remember, portability doesn't apply for generation skipping transfer tax purposes. Let's go to the next page, up to page 7. Now, this journey starts with doing a balance sheet for husband and wife and understanding what he owned when he died and what she still owns. So we have to understand that. Now, remember,
Sorry,
community property is going to be 50-50. Go ahead, Marty.
just a quick comment. This is so important what Bob's talking about, and I so often see this done wrong. And especially for financial advisors listening, this is a golden opportunity to give a value add to clients. You first have to understand what the estate plan is, and Bob's going to go through different options. Like if there's a reason to fund a credit shelter trust, and there very well may be, Bob's going to talk about it. The clients have to have title to assets consistent with what the plan is. If the goal is to fund a QTIP trust, and Bob's going to talk about that soon too, you need to have assets in the spouse's name that dies, or they're just going to transfer by operational law. So once you first understand the plan, review how different assets are held. And it's often on the financial advisor because clients don't come back to their estate planning attorney frequently enough. And often it's the financial people like the banks, the brokerage firms, the investment wealth management firms that are titling a lot of critical assets. So this is really important to look at.
So Marty, the first thing we would do is we'd lay out all the property the couple owns, and then we would endeavor to determine between H and W who owns that property. So between the spouses, who owns the property. And sometimes in a community property state, Texas, California, Washington state, easy. Because everything, these kids were married when they were 24 years old. They never look back. 60 years later, somebody dies, it's all community property. If people move states though, Marty, so they were married in Indiana at age 25, at age 30, they moved to or call it 35, they moved to California. It's not going to be very clear. Now, most time in those situations, you get a transmutation agreement where you opt into community property. But this is the type of thing we want to look at. If there's anything that's not clear, the CPA preparing these returns needs to talk to the lawyer and just put their heads together and figure out what do they have. Now, sometimes you have to go back, and it's an awful process forensically, and figure out what people owned. But
costly too.
It's costly. The CPAs that do that are paid very well. Now let's go to the next page. So normally 9 months after death, you have to file this return. You have a 6-month extension. The extension is merely for filing the return. The payment deadline remains. So if you owe tax, you have to pay it. No choice on that. The extension form on page 9 is a piece of cake. No one's going to struggle with filling this out. The important thing is, if you have closely held business or there's any chance of an estate tax, you want to make protective elections under 6161 and 6166, just so you're not penalized if somehow you owe a tax. Now on page 10, both the charitable and marital deductions are unlimited. But Marty, if my estate was 30 million and I left it all to my wife, do I have the right to file late for portability? The answer is no. The test of whether you have to file a return is predicated upon your gross estate before any deductions. So I could have $30 million estate, all to charity, all to my wife. No one argues there's no tax, but you can't go back and fix portability in that situation. The exemption is predicated upon the gross estate. Now, if you look at the next page, amended returns, there's a procedure on the amended returns. That's a different class, but basically no special form. You just file a supplemental 706. Very important to understand that. Now, the other thing that's super important to understand is that if H died and you didn't file, W dies and she is over the exemption, and you do not get portability fixed quick enough. Now, in other words, you go for a ruling, Marty, and you don't get it back before W's return is due, W has to pay that tax. She can't just arbitrarily use her husband's exemption. And after you get the private letter ruling approved, you go back and you file an amended return for W. I had this, okay? Government was very good about refunding that money quickly. Wasn't a problem at all. What we did is we filed the amended return for W. We attached a copy of the PLR from H's estate so that the person at the service center would see exactly what we were doing. Next page. Now, we do have to watch our statute of limitations. If H died, let's say in 2015, and you're going for a PLR, and W died in 2022, we're up against a 3-year statute in 2026 probably. So if you got that far and you hadn't, and your PLR didn't come back yet, you're going to have to watch that 3-year statute. And if you get yourself sideways on that, you simply will file a protective claim. Okay, you'll file to keep that return open. Okay, so you have to be very, very careful with that. Okay, let's go up to page 14, please. Now, the exemption amount, $13,990, husband and wife together, $28 million. We'll just use $28 million for discussion purposes so we can quickly do the math. Portability simply allows my exemption to be ported to my wife. So if I died today and my exemption was ported to my wife, she would have $13,990 times 2. Okay, it's that simple. Remember, this doesn't work for GST, but it does work for gift and estate tax purposes. Now, interesting enough, go ahead, Marty.
Just a quick comment. What you just said is really important to focus on. I tried to emphasize in a prior comment how for smaller estates, this should not be ignored because we don't know what might happen to the exemption in the future. And boy, what a waste if the exemption is reduced by some future administration to $1 million or $2 million and they didn't elect portability. On the higher end of the spectrum, not planning to use GST exemption is huge. Think about what happens, and I don't want to belabor this because it's kind of ancillary to your discussion. If estate tax repeal occurs, if we haven't locked in the GST, we don't know if we can even use GST during a period of repeal, and if estate tax comes back, what happens? If we have a large estate and estate tax repeal doesn't occur, what a shame to lose the GST exemption so that future generations now have to face planning or a potential tax. So the fact that you can't use portability for GST should be very significant in the planning for larger estates.
Well, absolutely, and that's a reason right now. Maybe if somebody dies, if it's a choice of portability or a disclaimer, we disclaim and fund that bypass trust because we can allocate GST exemption to it. And we're going to be in this. If we get repeal, we'll be in this purgatory, Marty, where nobody will know exactly what we have. Okay, now, so there's this Tax Reform Act. It created a new concept called portability. And basically, maybe there's an argument for some clients, there's no need to fund a bypass trust at the first death. And we're going to talk about that a little bit. Look at page 17, please. Now, one very scary concept is the concept of the last deceased spouse. So I think you might have been the one, Marty, many years ago to call this the King Henry VIII rule. And basically what is going on here is I can only use my last spouse's exemption. So I was married to A, and she died, and she gave me $13,990,000 of exemption. And then I married B. But when B died, she left all her property to her children, and there was no exemption left. I now have B's exemption. And you can't override this in a prenup. There's nothing you can do to fix this. But if you're the lawyer representing someone in a prenup, if you're representing husband in a prenup, you better tell them, hey, you have your wife Agnes's $13,990,000, and if Betty dies first, you're in trouble. Okay. Now,
Bob, I don't know if you want to mention, but isn't the prudent thing to do to gift that DSUE almost really before you remarry, so you don't have that risk, so you preserve it?
Excellent point. The ordering rules when you make gifts are DSUE first. So Marty, before they got married, husband could, if he could afford to, he could gift his wife's $13,990. Now there'd be carryover basis, etc. But at least then he'd burn up her DSUE. And if Betty drops dead the next day, he's good. He doesn't have to worry about losing his DSUE. Now the other thing is, let's just say that Betty didn't bring any assets to the table. In that prenuptial agreement, Marty, you want to, if you're representing H, you want to negotiate that at H's expense, Betty's family will cooperate, her personal representative will cooperate with filing an estate tax return so that her portability is transferred to H. Now, the other thing you would do is you'd probably, the estate planning lawyer handling her will, if that's what she wants, if that's one of their goals, would draft that into her will, that my executor shall, not may, shall cooperate with my husband's family at my husband's family's expense to file an estate tax return for my estate.
Quick comment. That's another very important planning opportunity that Bob just said, and I just want to emphasize it. If you're an accountant and somebody comes to you that was filing single returns because their spouse died, and all of a sudden they come to you and now you're doing a married return for that person and their new spouse, immediately talk to them. And I would put it in writing, because if they don't do it, you don't want them coming back and blaming you. Just say, hey, you need to address planning for your deceased spouse's exemption, the DSUE. If you don't tell them and they don't do it, you don't want them coming back and complaining to you. And it's a huge opportunity. So I think that accountants, when they see a change in status on return, that should be a light going off that you need to do something. Financial advisors, client, their spouse died, they're planning on getting remarried. This should be part of the conversation. It should be part of your checklist. And I don't know, Bob, if a lot of these AI programs that advisors are starting to use to do so-called estate planning, financial planning, I don't know that they pick up stuff this subtle. And this is really important. And a final point, when planning to use the DSUE of the previous deceased spouse, one of the issues is, well, do I really want to make a gift? I think part of the problem with that hesitancy is that most clients are contemplating, I don't want to give it to the kids now, I may need it. You can set up a self-settled trust. You can set up a SPAT. That's beyond what we're doing today. But the point is, you can create a trust that the client themselves can benefit from in various different ways. So there shouldn't be that resistance to using it, because if the new spouse dies, as Bob said, that's all gone.
And Marty, I want to make clear that what you talked about is the right thing to do, no doubt. But it is way above the standard of care. I would be surprised if 1 out of 1,000 CPAs could properly describe that issue to a client.
But that's why the financial advisors and even the accountants and even the attorneys, if you're a general practice attorney or just doing basic estate planning, consult with somebody. These issues could be very, very significant. Very good point, Bob. Yes, not a standard of practice at all.
I think where we are in both law and accounting, if the exemption stays this high, you'll basically see a very sharp dichotomy of when people help with estates. Meaning, if my estate, let's just say I'm a single guy, if my estate is above 14, my CPA, my normal lawyers will all handle that. But if I'm at 20, they'll refer that out to somebody that just does that. Because if you look at, like, in a community of 100 or 125,000 people, 200,000 people, you're only going to have less than 5 CPAs and 5 lawyers that understand this stuff. And, and that's going to get worse as time marches on, because anyone that graduated after 2010 has not had a steady diet of taxable estates. Marty, when you graduated, the exemption was $600,000.
Yeah, and my diploma was so long ago was actually on real sheepskin.
But no doubt. But now portability. Let's go up to the next slide. So you have to file a timely and complete 706. It can be an abridged 706 for property going to my wife. So if I leave my wife the house and the cottage in my car, it's okay to use property tax bills on the house and the cottage and a Kelly Blue Book type thing without an appraisal on the car. No, the government's not going to care about that because the regs are clear on this. But if you think about it, the government will have another chance to look at the right amount of tax when my wife dies. So if we said the house was worth 500 when I died, and later when she dies, we get a real appraisal and it's worth 2 million, that's fine. The government gets its tax then.
Bob, how do I know that I got the right basis step up if I'm kind of just seat of the pantsing the value?
You don't. You're just going to accept what you used from that property tax bill.
And what if your number is low and you lost potential basis and the client then thereafter incurs a capital gain they could have avoided if you had it valued properly? Isn't that an issue?
It's an issue. We had that on a PLR where we tried to fix something and the government wouldn't let us fix it. And the thing about it is, with the exclusion for selling a house, Marty, at 250, most Americans wouldn't be adversely impacted by this. So if mine and my wife's house was worth $750,000 and I died, it's community property, she takes a 750 basis. If she should take an 850 basis, that delta would be sheltered by her 250,000 exclusion when she sold the house. But this can come up. I mean, it's certainly going to come up in those more expensive localities, New York, San Francisco, Los Angeles, etc.
I think there's 2 points. One we just made, you can save time and money by not getting an appraisal, but the client may get whipsawed when they sell it, when the surviving spouse sells it and doesn't have the right basis. You may, as a practitioner, want to just mention that to client, hey, we can avoid an appraisal on this business, this other hard to value asset, but if you don't get it valued right and you lose out on basis, if you sell it before the death of the surviving spouse, second death, you could lose. The second piece, which is much more subtle, and I was trying to think of a good example and I couldn't, you don't have to value with an appraisal something that's going, for example, for a or charitable deduction. But if you don't, what if the dispositive provisions in the estate plan, whether it's a will or rev trust, doesn't matter, are hinged on value? I give the family business to my surviving spouse and I make an equal bequest to my children from a prior marriage. How do you do that without having a real appraisal? So it's not just the tax issue, it's also interpersonal issues, dispositive provisions. So be careful what you do.
Well, absolutely, Marty. Now, page 19.
Sorry.
Let's go back to one more, please.
18?
19, 19.
Yeah.
So you can elect, even though you file a 706, you can elect not to have portability. You can elect out of portability. I've thought about this a long time. I think the only reason you do it would be out of spite. My dad dies. There's portability available, but I just detest my stepmom. And I'm not going to do anything for her. So I check the box. If one of your clients want to do this, help them find their better angel. Help them negotiate something where they get something in return for allowing for portability.
And that's something, like Bob said, if you have a prenup, you negotiate there that the surviving spouse getting the benefit of portability, they'll pay the cost of preparing the 706 to file to secure it. Why should like children from a prior marriage bear that burden? But like Bob said, spite is not a good thing. There's a court case, I'm blanking on the name, but it was a pretty significant case a number of years ago where exactly what Bob said happened. And the court said that the surviving spouse, I think the way they phrased it, had a property interest in the DSUE, and they held that the executor had to elect portability. And like Bob said, it was spite. There was no skin off their nose other than the cost of the return, which I'm sure the other side would have paid for. And I'm sure the litigation cost more than the return would have cost. So be very careful before you check that if it's just out of spite, because you may find yourself embroiled in a problem.
Now go up to page 22, Marty. So again, we have to start thinking about this. Always look at it through the lens of state and federal law. You have about a dozen states with their own estate tax. So if you're practicing in one of those states or the client has real estate in one of those states, we have to be careful. And the question is, if I die today at 63, there's a real good chance my wife will live to not and die someplace between 90 and 100. So at the end of the day, whatever we have could grow so much, Marty. It's you know, you can take your fancy dancy present value calculator and figure it out or run scenarios, but that doesn't matter. If there's any chance that that's going to happen, you want to get that DSUE locked in. Now, we could, if you need asset protection, for example, Marty, if husband died and his wife was a physician, almost undoubtedly the better thing to do would be to, if she's still practicing, is to fund a bypass trust, because we can get those assets in a nice safe place where they're not subject to the claims of our creditors. The other place that requires some thought, deep thought, is what to do with IRAs. Because see, portability is a beautiful thing for IRAs, because I can die, leave my IRA to my wife, she can grab my DSUE, and then she's protected. On the other hand, what we would have to do before portability is push the IRA, push my IRA into a bypass trust. And of course, today we end up with the 10-year rule when we do that. So that's a real challenge. Look at page 23. Again, moderate wealth clients, go through this, run your scenarios. And the problem is, you know, the client tolerance for planning cost and complexity is sometimes pretty low. Now, we can do an efficient federal estate tax return if there's only 3 or 4 assets for well under $10,000. What I usually do, Marty, when I'm sitting with a family, is I will take and draw a fraction. And just everybody should do this right now. In the bottom of the fraction, I want you to put $5.6 million. And I always write out all the zeros so they can see that. And then, so that's the denominator. In the numerator, I put whatever the fee is, $10,000. And then people just, and I say, you know, would you pay $10,000 to save $5.6 million? It's not even, no one would even blush at doing that. It's such an easy decision, so straightforward. So we have to focus on the relationship of what it's going to cost you to do the 706 versus what it potentially would cost in taxes later. And these numbers are very real. Even if you assumed it was less than that, we can run the math. I mean, we can play with the math, but it just, and we can always take and extend the first return and then look at this in 13 months. And if you're below the exemption, Marty, you can sit on the sidelines for 5 years from when the first spouse died, not when that return is due, but 5 years from the first death. Okay, next page, please.
24, correct, Bob?
Yeah, 25, please.
Let me just make a quick comment on 24. I think one of the most important points in all the decision making in this planning is the first bullet point you have on 24. Asset protection is something that is so critical for so many clients. We live in the most litigious society in the history of this planet. I don't really care what the politics are in Washington. It's never going to change. And I think lawyers tend to be a little more focused on this perhaps than financial advisors and accountants, but everybody should be focused on this. The most tax that the government's going to take is 40%. A creditor could take 100%. So just bear in mind the importance of asset protection planning in any decision process that's made.
No, thank you, Marty. Now, malpractice traps, we kind of talked about this. When you file for, if I die, when you file my return, that statute never runs. The IRS can audit my return at any point in time until my wife's statute of limitations is run on her estate tax return. And the tax court affirmed how to look at that in the Sauer case, 149 TC number 11. So I have that cited there. So just know that's out there. Go up to the page 26, please. So when you're thinking about this is, what is the size of the estate? What is the surviving spouse's estate going to look like? Do we have is there any chance the estate tax law will change? Asset protection issues. Now, if everything comes to my wife, remember, Marty, when she dies, we get another step up in basis under current law. So that's a very powerful thing. If we go to the next page, remember.
Let me just comment before you do. Just contemplate how impossible, strong word, but intentional, these factors are. Like Bob said earlier, how can you predict when someone's going to die? You can't. How can you predict the growth on their investment assets? You can't. So how can you predict asset protection risks and issues? Somebody gets in a car accident and only had $500,000 of liability coverage. They could jeopardize their whole estate. So these issues are really significant. And I think this is why it's so important, as Bob said earlier, even on estates that seem well below the exemption, these discussions should happen with the client by whichever advisors are meeting with them about asset protection, uncertainty, about tax law changes, etc.
No, thank you, Marty. And remember, GST, no portability. So Marty, if GST is important, we either have to fund a bypass trust and allocate GST exemption, or we have to fund a QTIP and do what's called a reverse QTIP election. But if we did that, we can still use portability.
And by the way, a lot of people dismiss putting assets in a trust because they're thinking of a credit shelter trust and losing the basis step up on the second death. But as you just explained, if you use a QTIP trust, and there's lots of options, which hopefully we have time for you to get to, you have the ability to allocate GST with a reverse GST exemption. So you preserve the GST if their estate really grows or the exemptions come down. And you get them asset protection inside of a QTIP. It's not as strong, perhaps, as a purely discretionary credit shelter trust because the income on the QTIP must be paid out to the surviving spouse, but having the principal protected is a huge benefit. So if you don't want to do a credit shelter trust or the client doesn't feel it's worthwhile, really consider that QTIP for these benefits.
Now, Marty, let's jump up to page 32, please. Now, very, very important. Revenue Proc 2016-49. And basically, it said, even if you elect, you're allowed to elect QTIP, Marty, even if there's no tax due. And this was a result because it was a response to Revenue Proc 2001-38. So it's important to know that if I died and everything went into a QTIP, even if I'm below the exemption, even if I would have no tax anyway, you can still elect QTIP treatment. Now, the beauty of that, Marty, is later when I die, very technical, but under Section 2044, those assets are included in my estate. And because they're included in my estate, when you go back under 1014 of the code, you're going to find that there's a step up in basis. Why would I do that? I might do that for two reasons. One is I want to control the property. I want to make sure it goes to the right place when my wife dies. Secondly, the second reason I would do that is that I want to absolutely make sure that my wife has my portability, okay? And third thing would be GST, because you can make a reverse QTIP election to allocate GST to that QTIP.
And sorry for sounding like a broken record, but to me, it's really priority one, asset protection. A lot better than an outright transfer.
No one can argue with that. Okay, now go up to page 35, please. So 35 is just a little chart I put together. Basically, this is what we've danced around. So the choices are I can leave everything to my wife outright. That's that first column or first row. The biggest problem with that is no asset protection, okay, or limited asset protection. We could do the bypass trust. The problem with that is no step up in basis later when my wife dies. Now, is there a way to have our cake and eat it too? Maybe. We could do a bypass trust, Marty, but I could give my wife a contingent general power of appointment. And if her estate is only 10 million, but her exemption is 14, she would get a step up. She would include 4 million of my bypass trust in her estate, not owe 1 penny of estate tax, but get a step up on that 4 million. So that's a very good possibility. We have not fully explored as a profession how to use these GPOA trusts. And that's something that's very much developing a life of its own. And then we can do the QTIP, okay? So those are four choices. Now, you could end up with a dichotomy and use one solution for assets that receives a step up and another solution for IRAs. The best income tax solution for an IRA is a rollover. But it may not work for state estate tax. It may not work for as much asset protection. And it certainly isn't going to work for GST.
A couple of really quick comments, Bob. Many states will protect IRAs, but not necessarily if it's a rollover, maybe for a spouse. So you have to look at state law, very specific. What Bob was talking about with the bypass trust is a very clever idea, because one of the big negatives of a bypass or credit shelter trust is that you can't get a basis step up on the second death. So one of the approaches is to draft into that bypass trust a limited power of appointment to the surviving spouse. And in a second or third marriage, that may be an issue. But if the surviving spouse has a limited power and you give somebody the ability to convert it to a general power of appointment, or you use a formula, as he suggested, you can get that basis step up. Another approach for the basis step up, and depending if it's a second or later marriage, you may want an independent trustee, is to give the trustee that's independent broad discretion to distribute principal. So if it turns out that there's no lawsuits waiting to happen or nursing home costs that could decimate the estate, if there's appreciated assets, the independent trustee could distribute that principal to the surviving spouse and get a basis step up. Suggestion: if this stuff is complicated for what you normally do, print out this page that Bob created. It's a great chart. You don't have to even make the decision. Let him go back to a specialist to do it. But you can now have it, just with this one page, you can have an intelligent conversation with a client about planning options. And this is way beyond what is often done for more moderate estates.
So Marty, this little chart just walks us through the portability QTIP. And it's basically designed to determine, basically what should you do, okay? And I don't really want to go through this in detail today. I'd like to jump up to page 38 and go through some very practical situations. Okay, now we'll use last year's exemption of 13,610. Basically, the BIA amount that was 13,610. The deceased had a $3.4 million estate. So Marty, the question is, how much is DSUE? Just assume it's a multiple choice question. Is it 10,210,000? Is it 3.4 million? Is it 13.61 million? Or is it zero? And I think if you looked at that and you thought about it long enough, you'd say, well, wait a minute. The DSUE, if that $3.4 million went to my wife, the DSUE would be 13,610,000. If it went to a bypass trust, the DSUE would be $10,210,000. So it's the exemption minus what goes to what doesn't qualify for the marital or charitable deduction. That's going to give you DSUE. Now, the exemption might be reduced by prior gifts, so you just have to make sure you have your mind around that. Marty, let's look at the next page. Now, this is very important. DSUE is not indexed for inflation. So if your guy died in 2023, Marty, the exemption he gave to his wife is forever frozen at the exemption in 2023. It doesn't grow. If she lives, if she was 60 when he died and she dies at 100 40 years later, no change. No change in the DSUE. Now her BIA will grow with inflation, but
Barring a
his
change in the law.
or a change in the law, but his DSUE is frozen.
Hey,
Now,
Bob,
yes,
if the surviving spouse dies 20 years later, the inflation impact could decimate what the DSUE was.
absolutely.
What will eggs cost in 20 years, Bob?
I mean, I think they're like $8 a dozen now. So hopefully we will have figured that out. And what the price right now is a temporary thing, but just all.
The point is that the inflation is a huge factor on the DSUE, and I think people sometimes forget that.
And then the next page, Marty, which you have up, just shows, remember, when you look at this, look at it through the lens of what the law is. Don't even think about what the law could be. Think about the law right now, Marty. If you had to testify tomorrow morning in the courthouse in your county and you were asked, what will be the estate tax exemption on January 1st, 2026, you would say, give or take $7 million.
Yeah, and there's no assurance what's going to happen congressionally and politically with these amounts. So you got to really consider all the options.
So you'd want to look at that through the lens of the surviving spouse only having that half exemption. Or you mentioned earlier, perhaps even a little bit lower. Who knows what would happen?
Could be a lot lower.
Let's go up to page 41. So we have to balance the income tax and the estate tax. And the estate tax says to fund a bypass trust. But the income tax says to use portability. Because when I use portability, my wife gets my property and we get another step up in basis when my wife dies. So that's very important to understand. Now, when you run this math up on page 42, we'll start to set up the algebra here. But you have an estate tax, a GST tax, a gift tax. You might have a state inheritance tax or state estate tax. That's your transfer tax part of the equation. But then you have an income tax part of the equation, which you have to bring into account too. And interesting enough, we'll talk about the value of the step up in basis. The next page, just a quick snapshot, and this may have changed, but we try to keep it up. This is where we are with state estate tax right now. Okay. Now, core assets, basically, we have asset protection, bloodline protection. If we are thinking about what can go wrong, Marty, A is my beneficiary could be sued. B is my wife could remarry and leave all of the property I worked so hard for to her new husband. C, total change in character and behavior of my wife. She could become a spendthrift, and basically live at Talbert's, okay, where buying new clothes every day. Now, or, she could exercise a power of appointment in the way that I would never have envisioned. Now, page 45. So when we look at this, we have to decide what is the value of a step up in basis. When I die, there's a step up. If it goes to my wife, she gets my stepped up basis. And later when she dies, there's a second step up if it goes to her. If it's in the bypass trust, no step up at her death. And the interesting thing is, you could give a CPA in California and a CPA in Florida a factual situation, and their advice could be perfect, spot on, and be totally different. Because the step up in California is worth 13, 14 points more than it is in Florida. And that's why it's very important to run these numbers and to look at this. And very often, for the lawyers, it's very common practice when you're deciding whether to disclaim or not, to have the CPA run spreadsheets and basically say, if Mrs. X dies in 5, 10, 15 years, at these points in time, this is the right result under these situations, or this is the mathematical result under these situations. And then you have to blend with that the qualitative issues we talked about, asset protection, et cetera. This becomes especially difficult with IRAs. Normally with IRAs, Marty, in a first marriage, the rollover is going to be your go-to.
Mm-hmm.
But in a second marriage, not so much, right? You can't, if it's a second marriage and H leaves his $6 million IRA to W, hard to say what W is going to do when she dies.
I'll give you the perfectly correct answer for that. It depends.
No, it depends, but
you have to really evaluate. The point I'm making, to be serious, is you have to evaluate the circumstances depending on the relationship and whether there's kids from a prior marriage, what other assets there can be to assure it. It really depends. I agree with your comment, though, that for an IRA retirement plan, rollover is often the best option. And sometimes what you can do is use other assets or an insurance plan, in an ILET, to fund gifts to prior kids from a prior marriage and still get the rollover. But the point is, it depends. You got to really look at the assets and the plan and what their objectives are. Very hard to take a pat answer to that.
Now, page 47, this is where it really gets interesting. These are the 7 things you could do for someone, Marty. You could tell me to leave it all to my wife. You could tell me to put it all into a bypass trust. We could put it into a bypass trust, but give my wife a GPOA on a formulaic basis. So she would have a GPOA to the extent she had extra exemption left. Now, we could go the QTIP route. The beauty of the QTIP is a second step up when my wife dies. But the bad part about the QTIP is inclusion in her estate. In many ways, 3 is better than 4 because we have that GPOA. The GPOA would give us some step up. Now the other technique is we can do a Clayton QTIP where we do not make 100% QTIP election, or I could leave it all to my wife and then she could make a gift. This was actually something when all this broke that Jonathan Blockmacher came up with, and is pretty smart, because if I give it to my wife and she drops it into a grantor trust, she's paying those taxes, Marty. Maybe for 20 or 30 years, she's paying the taxes on behalf of our children. Now, or you could take some type of Solomon approach and combine 2 or 3 of these ideas.
Bob, I know we're pressed for time, but can you take 30 seconds just to explain Clayton QTIP for those that may not know what it is?
Sure. I would, when I did the estate tax return, if the QTIP trust was funded with 15 million, let's make it 20 million. The QTIP trust was funded with 20 million. I would only elect QTIP treatment for, call it 6 million, and I'd let 10 million of it be taxed. And then arguably the part that I didn't elect would be treated more like a bypass trust. And in some drafting models, my wife doesn't even get all the income off that portion.
But the key is it's flexible. And to me, just look, I think a combined approach and flexibility is really important because of the incredible uncertainty we have. So if you give a Clayton QTIP and an independent executor, which some say you have to have, can elect the QTIP election and thereby shift value to a bypass trust. And if that bypass trust has an independent trustee with discretionary principal distribution or contingent general power of appointment or both, I think you're building in a lot of flexibility. The practical problem with that is a lot of clients don't want the cost and complexity, but flexibility is really a great thing to have. So it's a trade-off yet again.
Absolutely. Marty, I won't take you back to high school, but on page 48, for anybody that wants to see this, there's the algebra. And my son, who has his engineering degree, confirmed that he was very shocked that I got this right. Okay, page 49. Now, here's a concept. There are 3 zones that we're worried about, Marty. There's the no tax zone, which is at the bottom. There's the portability planning zone, which is kind of in the middle, and then there's the estate tax planning zone. And if you use a piece of software, you can kind of predict, not perfectly, where someone is going to be. And this little piece of software we built will show it at 5, 8, and 11%. And the reason we do that is we just want to see under a variety of circumstances how aggressive we should be on gifting and other things for the surviving spouse. Because maybe we don't have to do anything. Maybe there's almost no circumstance where, as long as she has her husband's exemption, she will have to do anything. Okay, one more little bit of algebra on page 50, and then let's jump up to page 51. We'll talk about the value of the step up. Remember, in Florida, the eventual step up is worth 23 cents and the estate tax is 40. Those are the things you're comparing. But in California, if you look at the next page, I brought this up before, the estate tax is the same, but the income tax is higher, okay? And you can adjust this. I mean, this is meant to make us think, not to give you precise numbers to use. Now, if I leave everything to my wife, the problem is no GST and that DSUE is frozen. The good thing about leaving everything to my wife is we can do the IRA rollover. So that's a great thing. If you look at the next page, bypass trust, the problem with that is no step up in basis at the second death. And at best, a 10-year rule with regard to the IRA. So those are things we have to balance. If you look at page 56, excuse me. And let's keep going because this is all pretty easy for people on this call. And go up a couple more, Marty. There we go. General power appointment. Now, this might be our final thought. But Marty, when you draft my bypass trust, you can give my wife at her death a power of appointment. And those come in two flavors, limited and general. The general power of appointment, specifically black letter law, is included in my wife's estate. Now, you would do that on a formula because you really don't want my entire bypass trust in her estate. You just want enough of my bypass trust in her estate not to cause her to have an estate tax. But the beauty of that is if it's included in her estate, it gets a step up in basis. So these are all things we can do and kind of work together on. Look at page 61, please. So the law is very clear. If property is included under a GPOA, you receive a step up in basis, okay? Again, black letter law, pretty straightforward. Okay, next page, please. So we can have a lot of flexibility with a GPOA, and I think it's something for people to consider as one tool in your toolbox. And let's look at the next page, please. So at David's death, 100% of his $3 million passes to a bypass trust, and $2,340,000 of DSUE ports to his wife Viola. Viola has assets of $5 million at her death. Her total BIA plus DSUE is $7.8 million. So she has an exemption of $7.8 million. Her assets are only $5 million. Go up one more page, Marty. So basically, and what Viola is going to have, if her estate's $5 million and her exemption is $7 million, she would have a $2 million step up in basis, okay? She'd have $2 million. And many lawyers will draft that, Marty, to prioritize the lowest basis property is what's subject to that step up. So, Marty, we have covered a lot of ground today. Do you have any final comments?
Yeah, I think just to highlight a couple of points. This is really important. It is often overlooked. If it's something you don't understand these materials alone will enable you to have a reasonable discussion with the client to help identify issues, get the client or bring in a consultant to help you if it's not something you do. The 2 pages, if you do only one thing, the 2 pages that Bob has in the slides that he prepared, the one with the blue chart that shows you the pros and cons of different options and the other that lists 7 options, the one thing that I think will really help protect practitioners, because as we said, you can't predict growth rates. You can't predict when someone's going to die. You sure can't predict what's going to happen in Washington with the tax laws. Give the client options. Bob has outlined a whole bunch of options and a lot of the pros and cons on just 2 slides. If you sit at a meeting with the client and talk about that when they're doing estate planning, whether you're the attorney, the financial advisor, the accountant, you've now documented for your file that you've given them options, because the predictions are very uncertain. And I think that will not only make the client feel they got a value add from the planning you're giving them, but it'll also help protect you as a practitioner. And don't ignore the smaller estates, because the use of trust, the securing of portability, given the great uncertainty, can make sense from clients from a much lower level than I think most people consider. And at the higher wealth level, where Bob illustrated, potential for taxable estates, don't overlook that someone could have a high growth rate and we may have a lower exemption. So you really need to balance both ends of the spectrum, even for clients that may seem quite moderate. Bob, any other thoughts?
I just want to thank everyone for spending an hour with us today. Hopefully you learned a little bit about portability. Remember, you have 5 years. I die. If you fail to file, you have 5 years to fix that. If I was under the exemption to start with, and if you get beyond that 5 years, you can always go for a private letter ruling. We've literally done about 25 of those rulings, Marty. So we're certainly willing to help.
I've sent clients to you because you're so efficient at it that I can't get it done anywhere near for what you can do it in terms of time and effort. Thank you everyone for joining. Be careful. I forgot the exact quote from Hill Street Blues, but it can be dangerous out there. So be careful, and I hope that this was informative. I think the slide deck is really valuable. Bob did it all. I just got my name on it because he's a nice guy. Review the slide deck, keep it as a resource. Lots of opportunities for all practitioners and all disciplines to give a value add to clients by picking this stuff up. So stay attuned to it. Thank you.
Thanks, everyone.